Good evening, everybody. Thank you so much for coming, for paying attention to this important topic, WHO's new regime, new treaties. We are speaking about interruptive measures, interruptive rules that interfere with our lives, that interfere with our democracy, with our rule of law. And coming straight to the point, there's a very simple rule for constitutive lawyers and courts, and that says the longer and the stronger the interference with the ordinary constitutional order, with the ordinary life of people, and the more people are concerned, and the longer this interruption goes on, the stronger must be the justification. And if we look into the future, and if we talk about future agreement, then this rule must be adapted into the stronger the potential interferences with our democracy, with our rule of law, the more profound must be the public debate. And we see that we are about to conclude. 194 member states of the WHO are about to vote about 2 different international agreements that will interfere with our lives, that will interfere with our democracies, will interfere for everybody and for an unlimited time without that there's any debate visible in the public, in the parliaments, in the newspapers. And there are some brave exceptions, and I'm very proud that one of those exceptional members of the parliament with the longest legacy in Europe, the UK Parliament, is here, Andrew Bridgen, who insisted already some years ago that it should be subject to a public debate whether the mRNA vaccines did more harm than good, the excess mortality, and since more than a year now also that Andrew Bridgen insists that there be a debate about WHO and their new treaties. Therefore, with all due respect to Andrew Bridgen and members like him, he is a great example in this respect. Thank you so much, Andrew, for what you're doing. Yes. Now, having said that, we are looking at a regime that is intended to be voted upon 2 new treaties in May this year under the title of New Pandemic Treaty and amendments to the already existing international health regulations this May in order to strengthen the WHO, to strengthen WHO's capacity to prevent pandemics and react on it. My name is Philipp Kruse. I'm an attorney at law. When COVID-19 started, I was for 17 years a tax lawyer. I started being an ordinary business lawyer in 1997, and I dedicated since end of 2020 my professional life to having mandates, unconstitutional mandates subject to the judicial reassessment, and I have done more than 25 ordinary court procedures. The biggest procedure I have now submitted the second updated version of a criminal complaint against Swissmedic, which is the highest medical supervisory agency in Switzerland, and that will be published as well, like the first version will be published as well this month. Now, let's start directly into the topic. What is the key issue here? So the officials try to reduce the entire debate on the issue of sovereignty. And here we see Dr. Tedros Ghebreyesus, the Director General of the World Health Organization, relentlessly confirming that no country will cede any sovereignty to WHO. Most recently, he confirmed that on 22nd January this year. And I want to actually oppose that view by saying, number one, it's not just about sovereignty. We are talking here about the most fundamental pillars the actual fundament of democracy that we have all in our constitutions, whether it is the Norwegian constitution or any other constitution, more or less in the same way since the times of the French Revolution. What pillars, what fundaments of democracy and constitution do we speak of that are the same for every country? You have had these in school. You might have forgotten about it. Number one is to have an effective system of checks and balances. It must be possible for the citizen, for the ordinary citizen that is violated in his civil liberties, to have an act of the government or even a law of the government that violates significantly his rights, to have this act being subject to a reassessment and to correction. This is based on the notion that all of these three elements, the government, the courts, and the legislature, have the same equal weight and therefore balance their powers, as opposed to the situation before the French Revolution, where we just had one emperor who held all the power in his hands. And this one emperor was the rule of law. He could, in the morning, decide upon whatever reason what shall be the level of the taxes and against what country he wanted to go to war. We have replaced that, or the people who fought the French Revolution and the other revolution replaced that by the rule of law. And I will show you that the rule of law will come under fire under the new pandemic treaty, and in particular under the amendments of the international health regulations. But there are more. The most important fundament of democracy is free speech. The right to exchange information, to obtain information, and to exchange your opinion. If you take just that away, and if you just allow one certain perspective alone to prevail in the public arena, you kill democracy. You cannot have democracy by definition. You cannot have any science, by the way, because also the science needs the free spirit of thesis, antithesis. The same goes for the judicial system, because for every position there's a counterposition, audiatur et altera pars, and of course, ultimately, democracy with pro and cons. And then, let's not forget, but in most countries, the matter of health is directed and governed on the regional level, and not even on the national level. Now this shall be taken up on the global level as soon as WHO considers that there be a pandemic. Having said that, let's look at the timeline. First, to make it very clear, we have two international agreements. A complete new international pandemic treaty. It's about to be negotiated, and we do have the latest draft from 30th of October. It's on the table. We can look at the provisions. And then we do have the international health regulations, which are not new. They exist already since they have been adopted by the World Health Organization in 2005 in the present version, and they are subject to a major revision. We are talking about the amendments that are on the table since end of November 2022, unchanged. Although the states are in an intense process of negotiation, and we don't know what the current status of negotiations is. So all I'm going to tell you is about what we have on the table since end of 2022, international health regulations. Now, one other aspect which is very important with this new treaty, based on the WHO's own constitution, it requires a 2/3 majority of the member states for adopting this new treaty, and then, in addition, for making that coming into force, the constitutional domestic procedure for ratification must be observed. So there is a certain minimal guarantee for a public debate. Not so for the international health regulations. There will be no public debate. First, it will be sufficient to just have a simple majority at the vote next May, and then it will come into force by way of an automatism, automatically, unless 10 months after its adoption, that means until 31st March 2025, the government will send out and issue a formal notice of rejection. Without such a formal of rejection, the international health regulations in the amended version will come into force on 1st of June 2025. Now, as this is a much lower threshold, and most of all, as the most harmful provisions we will find in the amendments to the international health regulations, I am now going to focus on these most critical points of the international health regulations amendments. Let's jump directly in it. Number one, there's a very simple mechanism for the Director General to declare a pandemic. And as such a declaration brings with it a number of competences, we must call it self-authorization. He can just whisper the word public health emergency of international concern into the microphone of WHO in Geneva, and it will be so. It will be the word of God. There is no standard whatsoever that can be checked, that can be reviewed, and upon which he is accountable in order to declare a public health emergency of international concern. That was already so far the law. Just as you know, the last public health of emergency of international concern started 1st of January, it was called out 2020, stopped 5th of May 2023, so 3 years, 3 months. Now, what we are interested in is, will it become more difficult or easier for the Director General to call out and to declare public health emergency of international concern? The abbreviation is FAKE. We have an Annex 2 related to this Article 12 I just showed, and that is a decision tree giving examples in which cases he might call out and declare a fake pandemic, like, as an example, human influenza caused by a new subtype. We all know that human influenzas appear to be every year with a new subtype. Or infections in which human-to-human transmission cannot be ruled out. Severe infections, I should say. So this probably allows literally every potentially severe infection to give rise to a pandemic. But that is not enough. We have the wide concept of One Health. This is a very wide concept. It is discussed about for more than 15 years. Many scientific papers have been written about it to give it the scientific appearance of something that can be really measured and standardized, but which ultimately allows the Director General to whatsoever reasons, as soon as it has to do with climate change or biodiversity loss or ecosystem degradation, literally with decline of water or other resources, to declare a public health emergency of international concern. You may remind in Germany last summer, when there was some hot days in Germany, they started to talk about the emergency because of the heat and special emergency measures. And Tedros gave an interview where he said, yes, we see more heart attacks when it is hotter, so in order to prevent it, we might need to call out a public health emergency because of the heat. So what does this mean? We see that the justification for an emergency, these reasons are extremely extended without any standards, based on perfect arbitrariness. There's just one person, actually, who knows why such an emergency was called out. So all of this is in the sole discretion of WHO, which is not under the control of anybody else. And then number two is that you might have heard that the recommendations that WHO can issue in the future will have a legal binding force. This is denied by the public media. It is denied by the politicians. They will tell you Philipp Kruse is telling conspiracy theorists, no theories. Let's look how conspiratic or how much this is of a conspiracy theory. I give you 3 arguments. Article 1, where so far the recommendations were defined. So far we saw it defined as non-binding advice. Non-binding advice, but non-binding in the present amendments is striking out. Evidence number 2, the new Article 13a, which says state parties undertake to follow WHO's recommendations in their international public health response. So you might not know that undertake to follow is a legal formula. And every lawyer understands immediately this is a promise. This is a legally binding promise. And nothing else. It's not whether I want or not want. I have legally promised it. And there's a third very strong wording, and that is health measures taken pursuant to these regulations, including the recommendations we were just talking about, shall be initiated and completed without delay. Shall be initiated and completed without delay. This is an order. For those of you who have been in the military, this is how it sounds in military. It shall be initiated and completed without delay. Okay? So this is nothing but an order. So we have that in 3 explicit, very explicit provisions. But then we have also a lot of talks, a lot of communications from the member states and of WHO, which constantly speak about strengthening the powers of WHO. Also, the United Nations does so. So this, we must count on, will be one of the essential elements of the new international health regulations. And this is why I call it legally binding. So what will be legally binding? You have a list of potential recommendations already in the existing Article 18. I just highlight the most important one, like the recommendation to require vaccination or other prophylaxis. Means in the future you have to enforce, the member states will have to enforce vaccination or other prophylaxis. Or the member states will have to enforce quarantine or other health measures for suspected persons. Who are suspected persons? Those are the ones which WHO says, those are the ones who have not taken the jab, right? Or who are not recovered in case there's 2G or in case there's 3 options. Those who refuse to have themselves tested and cannot provide a negative result. So all of those who are just healthy and happen to be healthy and refuse to do any of these measures will be called suspected persons, and we must expect that quarantine camps is within the range of what WHO can impose or have the countries been doing. There will be then, talking about enforcement, an implementation committee, having everybody on the radar who does not implement these new regulations. In addition, because that's not enough of control, there will be a compliance committee reporting to the Health Assembly, which under the current version shall be given the authority to conclude about sanctions. Okay, this is just within WHO. Then you have outside of WHO, you have the World Health Bank, which can make the loans more expensive for countries, or the EU, which can exclude members from citizens from non-compliant countries from traveling. So, and so on, and so on. And the number one most harming provision and concept is the concept of infodemic that was promoted in public for the first time with the Event 201 in October 2019. Under the title, the question was, how do we make sure that people are properly informed? And the participants of this exercise, Event 201, said, oh, well, we might have to control information. And this is what they did. Since then. So this notion of information control censorship is also an important part of the new regime. We see it both in the International Health Regulations amendments and also and in the new pandemic treaty. So it is countering, they call it countering the dissemination of false, and that appears in 2 provisions of the International Health Regulations amendments, and then most notably also in the new pandemic treaty. So in both legal instruments we have the clear notion and legal basis to combat false, misleading, misinformation or disinformation. So this should ring the alarm bell, because we have seen that already in the past and still today. We don't see a debate in the parliaments. We don't see the figures in the newspapers. What about the excess death? What are about the risks related to the so experimental mRNA-based vaccines? We don't simply read anything about that. And my clients, mRNA victims, have to go to 50 different doctors until the first doctor says, oh, it could come from mRNA, what you have here, before they even consider it. So this now will be put into these new agreements. As we all know, if we don't allow information to flow freely, if we don't allow an open debate from happening, if you manipulate people with social pressure, by definition, you can never have democracy, science, fair jurisdiction, and never an informed consent. And not an informed consent, in particular, not only shameful, but it is criminal, because we have an international legally binding provision enshrined in the International Covenant on Civil and Political Rights. So this is the anti-torture article. It is considered to be cruel, inhuman, or degrading treatment if you give people wrong advice with respect to experimental substances. This is nothing less but that. And this applies even in times of public emergency that threatens the life of the nation and is officially proclaimed. This is deeply criminal, to have a system installed which very widely provides people with wrong information, right? So, and just as you know, the WHO Constitution does not provide any legal basis for global information monopoly and global info control. Now, this is an easy one, quick one, because these are all negative aspects. We don't see any aspect of checks and balances, and this is something that would have been already urgently needed for the past. If WHO would really be an organization that would care about public health, they would have for long already done a proper investigation about the origins of COVID-19 that, of course, as we know, came from a laboratory. They did not. And if they really would care about public health, then they would also be very careful about the side effects and negative side effects of these mRNA-based vaccines. And they exclude this information from a peer. So in the future, if we expect some mechanism of how to balance out this super accrual of power, there's simply nothing in it. Then in addition, who wonders, as also in the past, there's no mechanism of accountability. They enjoy, WHO and their officials, full immunity, and WHO and their officials enjoy full tax exemption. So you don't have to ask, actually, whether in the new pandemic treaty or in the international health regulations there will be any commitment with respect to fundamental human rights. You don't have to ask, because with such a regime here, allowing, for whatsoever reason, the Director General to declare a public health emergency, allowing him to provide the only applicable way of getting out of the pandemic, and everybody has to do it, and by allowing the WHO to control information, by definition, you cannot protect human rights, because the judge will not be in the possession of the right information, and he will always think that only WHO is right. So what all of that means, and I come now to the end, to the legal conclusion, legal assessment. And this is now the point I want to make. If we look at the entire concept, would you say that this is just technical regulative details about general standards that shall not be discussed in public, not be discussed in parliaments, and deserve a privileged treatment of just a simple majority vote in a distanced, non-democratic World Health Assembly, and then automatically coming into force? Of course not. If we have an interference, if we are pushing away our general situation from democracy into a totalitarian system, then definitely the people must be not only informed, they must have a saying. Because here we are talking about actually eliminating those pillars of democracy that I mentioned at the beginning. They will not be preserved and protected anymore. They will be easily suspendable. And all of that makes the international health regulations that come so nicely in the form of just technical things that might be, easily be accepted. Don't worry about it. It's such just technical. That makes them in true a Trojan horse. We have to unpack the true content of the international health regulations, and we have to hammer that into the public and into the brain of the politician. What is the true content of these international health regulations? They will actually kill our democracy. They will threaten our constitutions, and therefore they must be treated as if we would get rid of our constitution. So look into our constitution and find out what is necessary, what kind of procedure is necessary for the people of Norway to actually change so fundamentally your constitution, and you will have the response how to deal with the international health regulations. So this is it, and I thank you so much for your attention. Thank you. This should ring the alarm bell, because we have seen that already in the past. If we have an interference, if we are pushing away our general situation from democracy into a totalitarian system, that makes them in true a Trojan horse, eliminating those pillars of democracy that I mentioned at the beginning. They will not be preserved and protected anymore. This is deeply criminal. So you don't have to ask, actually, whether in the new pandemic treaty or in the international health regulations there will be any commitment with respect to fundamental human rights. They will actually kill our democracy. They will threaten our constitutions. Not an informed consent, in particular, not only shameful, but it is criminal. Because we have an international legally binding provision. Shall be initiated and completed without delay. This is an order. For those of you who have been in the military, this is how it sounds in military. It shall be initiated and completed without delay. And this is why I call it legally binding. This is deeply criminal.